we will witness today is a televised theatrical performance.
But since you learned it from others,
that's exactly
right. You could be wrong, right?
Why I'm here.
I mean, I've seen church prayer chains that are easier to understand than this.
If this is not impeachable conduct, what is?
And welcome to this special Facebook Live on the first public impeachment hearings in the House. They lasted 5 hours today. Next round of hearings will be on Friday. I'm Brahm Resnik. Thank you for joining us on Facebook Live. And we are joined today for some analysis of this hearing by a very special guest, the Phoenix attorney who knows something about impeachment, Paul Eckstein of Perkins and Coie. He was an attorney for the Arizona House in 1988, 31 years ago.
I was a kid.
A kid, just a young pup, prosecuting articles of impeachment against Evan Mecham. Mecham was convicted. He left office in April of 1988. Thank you so much for joining us, Paul.
You're welcome. Glad to be here.
Also want to let you folks know, please send us your questions on Facebook Live. Paul would be happy to answer them. Let's go back to 1988 because that might be distant history for lots of folks, but was a very important moment in Arizona history. What's the contrast between then and now, what we're seeing today?
The contrast is primarily that the Republican Party, which was the party of Governor Mecham, was the party that was pushing the impeachment rather than impeding it. And the Democrats were not quite sure that they ought to join in at the beginning. They did after the impeachment hearings in the House, but it was the Republicans that were anxious to get Mecham out of office because he was an embarrassment and would hurt them in the upcoming election. And that is one of the keys to a successful impeachment. While Nixon was not impeached by the House of Representatives, the House Judiciary Committee had passed articles of impeachment, and it was clear that the Republicans in the Senate were going to vote for the articles of impeachment, or at least some of them. And it took 3 Republican seniors, Senator Goldwater and Representative John Rhodes and Senator Smith from Pennsylvania, all of them stalwart Republicans, to go to the president and say, you don't have the votes. No one has done that, and I think it's highly unlikely that any Republican will do that for a long, long time.
So the Republicans in Arizona 31 years ago wanting their Republican governor out.
Absolutely. And it wasn't just the Republicans in the Senate and the House, but it was Republicans in any phase of life, in whatever their office. John McCain, for example, was a senator, and he was very much in favor of impeachment and conviction.
And let's talk about today, and before we get into the meat of the hearing, the rules of engagement, because this is something we haven't seen since Bill Clinton. 98, was it?
Correct.
Yeah. 21 years ago. Something we haven't seen in a while. Most people aren't familiar with how this is supposed to be carried out. Is this like a court of law? Is this something different? How would you describe it to somebody, what the process is for determining or ultimately deciding whether the president should be impeached?
Just when you think you have it figured out, you don't have it figured out. It's not a court of law. It's an impeachment. And what is going on in the House is definitely not like a court of law. It's not really like a grand jury. Some people have said that what the House does is equivalent to an indictment in a criminal case, and what the Senate does is equivalent to the trial. But what the House does is investigate, which grand juries do, sometimes behind closed doors, almost always at the end in an open session, and then they take a vote. So while the procedures look somewhat like a trial, like a judicial hearing, they're much closer to your traditional congressional hearing with a different kind of vote. And the vote ends up being, should the president be impeached, which does not mean removed from office, but should there be a trial in the Senate? And then it goes over to the Senate for a trial. The Mecham trial was a real trial. It lasted 6 weeks. There were witnesses, went on and off. And one of the interesting things about that is the senators, in the 30 senators in the Mecham trial, were allowed to ask questions And they did. And sometimes they messed up the testimony that the lawyers were trying to elicit on both sides. The Senate in the United States Senate has different rules for different kinds of impeachments. They've had a lot of impeachments, like 20 over the 200 and some years of our history. Most of them have been involving judges. The most recent impeachments are tried to a committee in the Senate, which prepares a report and then makes its case to the full Senate. That's not going to be the case here. We don't know exactly what the procedure is. Most importantly, who's going to set the procedures? The Chief Justice is the presiding officer. And ordinarily, you would think the presiding officer would have something to do with the procedures. But Majority Leader McConnell has said, well, one thing he might consider is a motion to dismiss as soon as the case comes over from the House, which wouldn't really, in my mind, satisfy the requirement for a trial. But the one thing that is almost sure is the Supreme Court, or no court, is going to tell the Senate how to try the case.
Okay, well, I'll move on to today's testimony. Ambassador Bill Taylor had some of the most compelling moments. Let's listen to one clip from him.
In the presence of my staff at a restaurant, Ambassador Sondland called President Trump and told him of his meetings in Kyiv. The member of my staff could hear President Trump on the phone asking Ambassador Sondland about the investigations.
That's Ambassador Bill Taylor telling the House for the first time about a conversation one of his staffers overheard between President Trump and the EU ambassador Sondland, in which Sondland says that, comes back and says, Mr. Trump, for him, this Ukraine was all about investigation.
Well, I thought the staff member could hear that. He could hear President Trump say, what about the investigations?
So how significant is that as a piece of evidence tying Mr. Trump to the allegations being made by the House?
Think of this as a puzzle with 1,000 pieces or 100 pieces, and no one witness has all the pieces to fill in the puzzle. Taylor played a very important role to set out the background, give the chronology. I think Vindman will be a key witness on direct knowledge of what the president said, because he was in on the telephone conversation listening to it between Trump and Zelensky. And he will testify as to what he heard the president say.
And that was a conversation that was the source of the original whistleblower complaint.
That took place on July 25.
So we'll have a somebody with direct knowledge of that conversation. And also,
can I say one thing?
Sure.
There is no trial that I am familiar with where one witness in a complicated case can supply all the evidence. And so you use witnesses in a different way. And I think it was smart for Chairman Schiff to put Zelensky and Kent on first, because they provided the background. And yes, they didn't have all the direct testimony. They had very little, but they were talking about people who had talked to Trump. And when you put on Vindman and some of the other people, I think it'll make a difference. The key here, of course, is the people who really know what Trump said, Trump, the chief of staff, and Rudy Giuliani, and maybe one or two, Bolton, haven't agreed to testify.
They're not talking.
They're the ones who have the information.
And so Republicans are pushing back on this phone conversation and some of the other testimony, claiming it's hearsay. It's all hearsay, it's a game of telephone, and this is being presented to Americans as actual evidence. What would you say to that allegation, or what their claim?
Well, first of all, not all the evidence is in. It's just begun. And as I said a moment ago, I think there will be direct recollection of what the person who is being charged here said. Hearsay is a concept that says any out-of-court statement is unreliable, except in, there are like 25 exceptions, and except where the defendant makes that statement. And here you have people reporting what the defendant said but not hearing it. And impeachment trials do not follow the federal rules of evidence. There is leeway there. And even if there weren't, the fact that the first two witnesses were not in on telephone conversations where they heard the president say directly what others have said they heard is hardly surprising. No witness, particularly one painting the background, is going to have everything to say.
Okay, I think we have some questions on Facebook. I'm going to get them. Oh, sorry. We're still looking for your questions on Facebook. I'm joined by Paul Eckstein, lawyer Perkins and Coie, who was one of the impeachment prosecutors in the case of former Governor Evan Mecham.
I may be one of the few people alive who's ever tried an impeachment case.
When
they
few
don't
people
get tried.
Alive? Is there a club that you guys?
Pretty small club. I wrote an article a long time ago saying, well, my specialties were impeachment and redistricting. And impeachment trials come along once every 50 or 60 years, and redistricting once every 10 years, and I starve in between.
Well, I hope you're not starving. I don't think you are. But please, if you have any,
at me that I'm not starving.
If you have any questions for us, please send them your way. Let's talk about George Kent and his testimony. We're going to have a soundbite from Mr. Kent. Oh, sorry, no sound from Mr. Kent. One of the interesting things Mr. Kent said had to do with Hunter Biden. And saying basically that Hunter Biden shouldn't have been doing what he was doing. Republicans picked up on that. How much of a dent does that put in the Democrats' case?
On the contrary, I think it makes Kent's testimony more credible and more believable. It shows that he's not partisan. And I think most people in the country and most Democrats would say, if you got them privately, yeah, that was kind of a stupid thing to do. Stupid is not the equivalent of illegal and is not the equivalent of impeachable. He wasn't even holding a public office.
And this idea, Democrats denying Republicans' requests to put the whistleblower on the stand, to bring Hunter Biden in, is that fair?
Let's take them separately. The whistleblower did not, as I understand it, have any direct knowledge. So if he came on and said he heard someone reported to him what had been said, they would say, oh, it's just hearsay. I don't think he has anything to add to what has already been said. Hunter Biden is, I call it in trials, pixie dust. You take pixie dust and you throw it in the air and you hope it will blind people. It has nothing to do with what Donald Trump did. And even if it did, Hunter Biden is not on trial. He's not on trial. And certainly former Vice President Biden is not on trial. He is not accused of being anything other than the father of Hunter Biden.
I want to get to a question from somebody watching us on Facebook Live. Was it Lynn Baker, I believe? And it's a simple question. I love simple questions. What are the impeachable offenses here?
The Constitution says that one can be impeached for treason, bribery, and other high crimes and misdemeanors. Most people, even many lawyers, think that the phrase other high crimes and misdemeanors must mean a crime at least.
An actual crime is defined by federal law?
Yes, and that is absolutely not the case. It has never been the case in all the impeachment trials that have happened. There often is overlap, and here there's overlap between bribery, which is specifically mentioned in the Constitution. There may well be extortion, and bribery and extortion being very close in definition in this circumstance. But high crimes and misdemeanors, as Alexander Hamilton envisioned it in Federalist Paper number 65, was an abuse of the public trust. The reason for impeachment was to remove someone who had abused the public trust. And I'll give you an example. What if a president had committed a clear crime? Say he had robbed a bank or beat up a former girlfriend, having nothing to do with governing. There's a real question, even though that was a crime, whether that would be impeachable, because it didn't involve something involving the public trust. And here you clearly have an allegation, at the very least, that what he did was a violation of the public trust. And more importantly, in my mind, is it's quite similar to what was alleged in connection with the Russian interference in the 2016 election. And the primary reason for impeachment is to get rid of someone in office who is a danger to the public trust and to the public, and who may, based on past experience, do the same thing again.
Okay. Let's talk. A viewer has a question about standards for hearsay. And you don't have anybody ruling on admissibility here, but what are the standards for hearsay as you apply them to whether somebody should be impeached?
The senators will make their own rules. In an ordinary situation, in the Arizona Meekum impeachment, the rules were drafted by ASU law professor Paul Bender and then presented to the Senate and adopted by the Senate. And my recollection is, I could be wrong about this, is that hearsay was admissible in the trial. But the senators are told that the impeachable offense must be proved by clear and convincing evidence in the Meekum impeachment.
That's a pretty high standard.
It's the second highest standard, the middle standard. And it remains to be seen whether that is the standard that will be used in the Senate.
So is it possible that, for example, this phone conversation that Bill Taylor relayed might not be admissible in the Senate if it's not corroborated by the staffer who actually heard it?
If this were a trial in state court or in federal court, that is most likely the outcome. As I said, there are 25 exceptions to the hearsay rule, and admissions by the person who is being tried is one of the exceptions. Now, the question is, if the person who listened in on this phone conversation testified that he actually heard the president's voice, that would be admissible. The fact that he passed that information on to Ambassador Taylor, Taylor's statement about what he heard would ordinarily not be admissible, because how do you cross-examine Ambassador Taylor as to what that telephone conversation was? That's the philosophy behind the hearsay rule.
So they have to get that staffer who heard the call.
That's the safest thing to do, and I think that's the most convincing thing to do.
Okay. And lastly, what are you waiting to see? The next hearing is on Friday. What do you want to see or hear from those witnesses that you think would build up the case or is needed to build the case?
Well, the staffer turns out to be a pretty important witness. And Vindman, Lieutenant Colonel Vindman, I've always thought is a significant witness. Others fill in part of the story and they make the hearsay more believable. But I just want to make this final point on hearsay. Just because there is hearsay evidence, and if there is hearsay evidence that is presented in the Senate trial, senators can reject it or they can accept it. But the rules of the Senate, which have yet to be adopted for the trial, to my knowledge, may well prevent it. We'll just have to see.
All right. Paul Eckstein of Perkins & Coie. He prosecuted former Governor Evan Meekum and is one of the few lawyers left who has expertise with an actual impeachment. Thanks so much for joining us.
Thank you very much, Bram.
And thank you for watching us on Facebook Live.